Employment law referees the relationship between employers and their employees. Almost always, the employer is the party in the stronger position, with power over their employee's source of income. Being dismissed from a job and losing that source of income can be incredibly disruptive and cause people serious difficulties. Accordingly, employment law mechanisms can step in when a dismissal is found to be unfair at law or otherwise wrongful, and provide dismissed employees with remedies. It is with these remedies that this report is concerned. There are two core routes to remedies in employment law. First, by operation of the Employment Rights Act 1996. Section 94 specifically allows for a legal claim based on unfair dismissal. Second, at common law, a legal claim can be brought for wrongful dismissal or breach of contract. While these are the core routes, I would just note that some alternatives do exist. I will deal first with the law of unfair dismissal and the remedies that it offers. Section 94(1) of the ERA states, "An employee has the right not to be unfairly dismissed by his employer." Section 111(1) grants a claimant the ability to bring a claim to an employment tribunal if they believe they have been dismissed unfairly. When an eligible claimant has been dismissed, the employment tribunal will determine the reason for the dismissal. That reason may be automatically unfair, in which case the claimant will have a remedy, or it may be potentially fair, and the tribunal will then evaluate the fairness of the reason in accordance with the test in the statute. Where the tribunal finds the dismissal, for the reason given, to be substantively or procedurally unfair, the claimant will have a remedy. The two categories of unfair dismissal remedies are re-employment and compensation. Re-employment can take the form of reinstatement, where you return to the job from which you have just been dismissed, or re-engagement, where you return to working for the employer but in a different role. Lord Justice Underhill described these as the primary remedies in the sense that the tribunal can only make an award of compensation where it has decided not to make an order under Section 113. By way of compensation, claimants can be given a basic award, calculated with a simple formula, and a compensatory award, based on what the tribunal considers just and equitable, having regard to the loss sustained. Both awards are subject to potential deductions. I'll now turn to the law of wrongful dismissal. Legal claims in this area arise from the common law and are inexorably related to the law of contract. There are various circumstances in which remedies may be available at common law for a dismissal. If a claimant is dismissed without notice, contrary to statute or their contract, and this dismissal is not justified by repudiatory gross misconduct. If an employer fails to follow an express term in the form of a contractual disciplinary procedure or a just cause term when dismissing a claimant, or possibly if an employer breaches an implied term of mutual trust and confidence or an implied duty of care. The main remedies that a claimant may receive are damages or an injunction. Damages are available following a summary dismissal to compensate for wages a claimant would have earned during the notice period. Damages may also be available for a breach of a just cause term. Since the cases of Johnson and Edwards, damages can no longer be claimed for dismissal on the basis that an employer has breached a contractual disciplinary procedure or an implied term. These cases fall into the so-called Johnson exclusion zone. It is unclear whether claims based on an express just cause term fall into the zone. Injunctions are available if an employee is dismissed with notice and is able to persuade the court that their employer should be stopped from dismissing them, because in doing so, the employer is breaking an express or implied term of their contract. While many topics could be singled out for evaluation, here we will look at three issues relating to remedies for dismissals. These are the duty to mitigate, the Polke deduction, and the already mentioned Johnson exclusion zone. It is submitted that these are flaws with the current state of employment law. The duty to mitigate in this context is a duty for the dismissed to minimize their own loss. It applies to claims under unfair dismissal and wrongful dismissal. In practical terms, it means that if a claimant is dismissed from their job, they must try to find a new job. They cannot claim lost wages from their employer if they could have been earning money at a new job. Over the long term, this is obviously sensible. If you are unfairly dismissed, it would be unreasonable never to seek a new job and to claim perhaps years of lost wages from your past employer. But in certain circumstances, this duty produces unjust outcomes. The first such circumstance is a claim based on unjustified summary dismissal. Whether it's prescribed by statute or the contract, when an employment relationship begins, the parties agree on a notice period. It is a breach of contract, then, when an employer dismisses without notice. The employee has a contractual right to their wages, and the law should unreservedly protect their expectation interest. But it doesn't. If the employee wants any of the money that they were contractually promised, they must find a new job, and then they may claim any difference from the wages of their old job. If they take no steps to mitigate their lost wages, they may get nothing. But the employee never agreed to this. It is entirely unreasonable that an employer can breach its contract with an employee and thereby force upon that ex-employee new obligations to go out and look for work. If they find work, or if they elect not to look for work, the employer is off the hook. This is why Freed calls the duty to mitigate an altruistic duty, especially because it is directed to the party in the wrong. Atiyah agrees that this is an example of the law forcing people to maximize profit or lose their contractual rights. A second problematic circumstance is when an employee is offered employment again by the same employer. When the new employment relationship is inevitably based on worse terms for the employee, they must nonetheless accept it or suffer for failing to meet their duty to mitigate. In the case of Polke and A.E. Dayton Services, the House of Lords decided that, where a dismissal is found to be unfair on the basis of procedure, the amount of an award for unfair dismissal could be reduced in proportion to the likelihood that, had proper procedure been followed, the employee would have been dismissed anyway. If the court is sure that an employee would have been dismissed anyway, it may even reduce the award by 100%. The principle that existed before Polke would reduce an award by 100% where the court was 51% certain. So, at the time, Polke was a step forward for employees. Bailey commented that the decision made procedural fairness essential to a fair dismissal. But it is submitted that Polke did not go far enough. Disciplinary procedures exist so that employers do not act arbitrarily, and employees can have an expectation of due process. The current iteration of the Polke deduction undermines that purpose. When an employer feels confident that their disciplinary procedure would result in a given employee being dismissed, then they need not worry about procedure. They can abandon procedural fairness and dismiss their employee on the spot, because the Polke deduction will reduce to zero their award. In Hunt and Market Force, the court did say that the Polke deduction itself could not affect a claimant's basic award, but Craig argues that the same circumstances that warrant a Polke deduction of a compensatory award can easily enable the court to use the statutory discretion under Section 122 to reduce the basic award too. So, unfair dismissal law doesn't provide employees with a procedural guarantee, but at least if an employee has an express contractual right to a specific disciplinary procedure, they can claim in contract law, right? Wrong. The Johnson exclusion zone almost always precludes this. The combined effect of these two flaws together makes each of them more problematic. In the case of Johnson and Unisys, the House of Lords had to decide whether Johnson had a cause of action at common law because, in dismissing him, his employer had breached implied contractual terms. The court ruled that no such common law cause of action existed, in part because, in establishing the framework for unfair dismissal, Parliament had intended statute to have jurisdiction over dismissals. Bernard and Merritt have argued that, while unfortunate for employees, the court's reasoning in Johnson was at least consistent with approaches to statutory interpretation in other areas of law. 10 years later, the joined cases of Edwards and Botham went to the Supreme Court to answer the question of whether there was a common law cause of action for an express contractual disciplinary procedure. The court once again said no. This decision took the Johnson exclusion zone from preventing the development of implied terms to nullifying express terms of employment contracts. This is where many critics rightly take exception to the reasoning of the Supreme Court. In fact, Lady Hale herself took exception in her judgment, saying that the key distinction must be between cases which must rely on the implied term to complain about the dismissal and cases which can rely on an express term. Again, the court relied on interpreting the intention of Parliament. They specifically relied on Section 30 of the ERA in doing so. Bogg argues that consideration of Section 30 reveals that Parliament had exactly the opposite intention as it pertains to contractual disciplinary procedures. The provision was never brought into force and was subsequently repealed, showing, Bogg says, that Parliament decided not to fuse wrongful and unfair dismissal. Collins argues that Parliament introduced unfair dismissal to strengthen the rights of employees, and so it makes no sense that Parliament would want to take away existing remedies. He called Edwards a brute policy choice designed to subvert the contractual rights of employees. Bernard and Merritt criticized the ruling in Edwards and suggest it should be overturned. They acknowledge that the greatest problem with taking this route is that it creates the potential for massive claims. But they rightly say that in the very rare case, the case that manages to get over the significant legal hurdles of remoteness and causation, if the court finds that a dismissal in breach of the contract has genuinely made it impossible for someone to find employment, why shouldn't such an award be appropriate? The overarching concern with the issues that have been identified is that employees, who are nearly universally the weaker bargaining party, are often unable to rely on their employer to hold up their end of the bargain and find themselves at the mercy of the employer. Employment law should mitigate the power imbalance between the parties. The identified issues make employees weaker. Accordingly, the decision in Edwards should be overturned. The decision of Johnson should remain. Collins, as well as others, concedes that the court's reasoning in that case is at least justifiable, but it is submitted that the decision in Edwards is unjustifiable. With Edwards gone, employers will successfully claim for breaches of express terms. Barnes identifies employees with market power as the biggest losers after Edwards, because they are left with very limited means of enforcing the terms that they negotiate. So, overturning Edwards could inspire more collective bargaining. The Polke deduction should be at least changed. Perhaps a maximum reduction of 50% is palatable for both sides. Employees should be able to expect a fair procedure, even where that procedure will inevitably lead to their dismissal. The argument for this is stronger while Edwards is still good law. The duty to mitigate should not apply at least to dismissed workers during their notice period, and in the plainly unjust situations where those dismissed are offered a new, less desirable contract. With these changes, employment law would move closer to striking a fair balance between the interests of employers and the legitimate expectations of employees. Thank you for listening.